If you have fathered a child out of wedlock in any state in the United States, then you can sign a document called a voluntary acknowledgement of paternity, and you will become that child's legal father. You got to be careful, though. In some states, it vests you with certain rights, such as the right to visitation, the right to custody. But in Tennessee, where I practice, it doesn't vest you with any rights other than the right to pay child support and have to support the child. You still have to go to court to get rights to visitation, custody, things like that. You got to be really careful, though, because I've had more guys that have signed a voluntary acknowledgement of paternity and then realized sometimes years later that they're not the biological father. But then it's too late to go back and change that. So once you sign it, you're kind of stuck there. I suggest everybody that's going to sign a voluntary acknowledgement of paternity have a DNA test first. It's easy, it's not that expensive, and it will establish conclusively whether or not you are actually the father of that child. It'll save you a lot of trouble in the long run. Jerome woke up one morning and his child support had gone from $250 a month to over $1,000 a month, and he didn't even know it. Well, here's what had happened. When he and the mother of his child broke up, 4 children actually, they had agreed on a 50-50 parenting schedule. He would have 50% of the time. She would have 50% of the time. The child support office set child support at $250 a month based on that 50-50 parenting schedule. Well, about 2 years later, the child support office petitioned the court on behalf of the mother of the children to modify the child support. When they did, they sent notice to Jerome's last address that they had on file. Problem is, he had moved. He never got notice. The case went to trial. Mom lied and said that he wasn't getting any parenting days, and the child support was increased to over $1,000 a month. Here's what Jerome did wrong. He didn't notify the child support office of his change of address. Guys, you've got to do that. Otherwise, the court is going to hear the case regardless of whether you actually got notice or not, because you are presumed to have gotten notice if child support sent that notice to your last known address. Keep up with that, guys. You'll get yourself in trouble if you don't. Husband took $100,000 out of his 401k that he'd been saving for retirement and invested it in his wife's business. They were both hoping that that business would be successful and could generate enough money for them to retire. It didn't. It wasn't successful. It went belly up. He lost every bit of that $100,000. Well, the parties got divorced about 2 years later. He argued before the judge that he should get that $100,000 back. After all, that was his retirement account, and he invested in his wife's business, being good-natured, and the business failed. Now he wants that money back. The judge said, no, you're not getting that money back. That was a marital transaction. It occurred during the marriage. You invested that money knowing the risk. If the business had been successful and was worth $2 million now, you'd be wanting $1 million of it, and I would give you $1 million of it. You took the risk. You're going to have to suffer the loss. What do you think about that? Do you think the judge was right in that regard, or do you think he should have given the husband his money back? Dad was paying about $650 a month in child support for one minor child. The problem was that he and Mom lived in 2 different states. Mom lived in Tennessee. He lived in Florida. So the way they worked out the visitation and the parenting time was that the child would go down to Florida and be with Dad the bulk of the summer, about 2.5 months. Well, one summer the child went down there to be with Dad, and Dad decided on his own that he didn't need to pay child support when he had the child during the summer. Why should he have to pay Mom $650 when he had the child and he was having to feed, clothe, and shelter the child? That wasn't a good idea. Mom took him back to court for contempt. He was found in contempt. He had to pay that child support back. Fortunately, the judge didn't lock him up for contempt because he really didn't have the intent to violate the order. He just misunderstood. Well, here's the deal. Child support is set really on a yearly basis, and you pay that out every month. And it doesn't matter how many days in that particular month you have the child, you still got to pay that set amount every month. In this case, it was $650 per month. What is a common law marriage? I've heard that term ever since I've been practicing law, and actually before I started practicing law. But what does it mean? What is a common law marriage? Well, a common law marriage is simply a marriage that exists by course of conduct of the parties. In other words, if you hold yourself out as being married and you act like you're married by living together, having children, whatever, then the state is going to consider you to be married. But here's the problem, is it only applies in a handful of states in this country. only about 7 or 8 states actually recognize a common law marriage. So most states require you to actually have a license to engage in a ceremony and then to return that license to the state so that they can put your name in a big book and show that you are married and you actually went through that ceremony. But here's the interesting thing. If you have a common law marriage in a state that recognizes common law marriages, then you go to a state that doesn't, well, that state that doesn't has to recognize your common law marriage.